Who's your power of attorney? I'm Ben Weaver, Illinois attorney, and I help people all over the Chicagoland area buy and sell houses and wills, trusts, and other estate planning documents, including power of attorney documents. And today, we'll take a deep dive into what exactly a power of attorney is in Illinois. All right, first question everyone always wants to know, is a power of attorney a durable power of attorney? And the answer is yes. You hear the name thrown around durable a lot because other states use it. And in Illinois, by definition within the Illinois law, power of attorney documents in Illinois are durable power of attorney documents. So you're all set there. Each state has their own set of power of attorney documents, and Illinois is no different. So I'm talking to you about Illinois power of attorney documents, but if you're in Indiana or Wisconsin or Utah, you probably want to go to an attorney in your state to find out specifics about your power of attorney documents. Now, in Illinois, there are two types of power of attorney documents. You have healthcare power of attorney, so you're giving someone else the ability to make healthcare decisions for you. And you also have property power of attorney. Now, property is really financial. So you're giving someone else the ability to make financial decisions, pay bills, that sort of thing, if you can't do it for yourself. Both power of attorney documents are signed individually, so you could have a power of attorney for healthcare, but not a power of attorney for property, or vice versa, or you could have the same thing. And it's your choice within the documents who you want to name as the agent. So you can have two totally separate people. One person is your power of attorney for healthcare agent, and one person is your power of attorney for property agent. Within the power of attorney documents, there's a lot of specificity you can make within the document. So you can have just the broad document that's already written in Illinois law, or you can narrow it down to have your power of attorney agent able to make only certain types of decisions for you. Now, for the financial, that's important because maybe you want to make sure that if you get sick, someone is paying the bills on the house, but you don't necessarily want them to be able to, say, change your retirement account. There's a perfectly good reason for that. Or for healthcare, maybe there's a certain type of medication that you are opposed to and you do not want to receive. You can make sure you add that into the power of attorney document so that your agent and your doctors and nurses and everyone knows not to give you that specific type of drug. It's all your choice, and you can modify those documents as much as you want. All right, so when do the power of attorney documents go into effect? Well, generally, for power of attorney for property, the power of attorney documents go into effect once a physician puts in writing that you lack the ability to make your own decisions. Now, it's your choice. You could have a power of attorney go into effect whenever you want to. It could go into effect the moment you sign the document. But in general, most people have it go into effect once they're sick and a doctor determines that they lack the ability to make their own decisions. For healthcare, it's generally the same idea. So it usually goes into effect once the doctor determines that you lack the ability to make your own decisions. But there is some leeway where you can have it set up so that your power of attorney agent is able to talk to doctors and nurses and healthcare professionals about your condition while you're still able to make your own decisions. So maybe it's helpful, for example, you could give your spouse the ability to talk to doctors about your condition so that if you go to the doctor's office, have an appointment, and then your spouse can call the doctor's office later on just to make sure that everything is understood what exactly happened at that appointment. Now, here's a good one. Is the power of attorney document, is it revocable? And the answer is yes. So you create the power of attorney document, and in the future, if you no longer want it to be effective, you can always revoke it. That's your decision. All right, so the last one, how is the power of attorney document signed? Well, for the power of attorney for healthcare, you have to sign it with a witness. Power of attorney for property, you have to sign it with a witness and a notary. It's interesting that the two different documents have two different signing requirements, one just a witness and one a witness and a notary, and that's a good clue as to how these documents are signed all over the United States. So, some states might have two witnesses. Some states may just have a notary. Some states may have two witnesses and a notary. It's best to sign it, if possible, with 2 witnesses and 1 notary, so that if, say, you're skiing in maybe Utah or Nevada or New Hampshire, wherever, and you get injured, that power of attorney document will work in that other state. It's always a good idea to make sure you have it signed by as many witnesses and notary as you think possible, just to make sure that it'll work in another jurisdiction. All right. Well, that answered some questions about the power of attorney, but do you have a power of attorney? Do you need a power of attorney for healthcare? Well, I have good news for you, because we are having monthly power of attorney pop-ups where we're creating POA healthcare for folks around the Chicagoland area. If you're interested in getting a free power of attorney for healthcare, click on the link and you'll go to the sign-up page where you can register for an upcoming power of attorney pop-up event to get a free power of attorney for healthcare. Any questions about power of attorneys at all? Leave it in the comments below. I'm Ben Weaver, Illinois attorney, and I'll see you in the next video.